hear from the appellant.
Agnes Trujillo for the appellants, Your Honors.
Pull the microphone over in front of you a little bit.
I was too short the first time.
I have that same problem.
Maybe please the court. I would ask for 3 minutes of my time to be reserved for rebuttal.
That'll be fine.
Counsel, this is an appeal from cross motions for summary judgment in a declaratory judgment action filed in the Circuit Court for Greene County. The facts below were undisputed, but instead the trial court was asked to draw some legal conclusions regarding its own full guardianship order that was awarded to the department in a prior separate surrender proceeding, which Mr. and Mrs. Burke, of course, were not participants in. Those legal conclusions were asked to be drawn given the backdrop of a 2018 child custody proceeding that was pending in an Indiana court of general jurisdiction and a 2019 dependency and neglect case that was filed in the Greene County Juvenile Court. Specifically, in the fall of 2018, the Burkes had arranged with a couple in Indiana to adopt the child who is identified as Plaintiff Jane Doe in this action. With the assistance of their Indiana attorney, they sought and received ICPC approval for the child to be placed in Tennessee for the purpose of adoption, and immediately thereafter filed 2 actions in that Indiana court. One, a petition for adoption, and the second, a petition for custody pending adoption. Now, custody pending adoption is a specific statutory creature to Indiana that is somewhat like our guardianship statute. It gives prospective adoptive parents the legal right to make decisions regarding a child that they intend to adopt. This child was found to be hard to place, which made her eligible for 4E subsidies, and thus the Burkes would be in a position where they would have custody of the child while negotiating with the state of Indiana. Now, in Indiana, legal custody, and this is an important piece of our argument, legal custody is defined as the right to determine a child's upbringing, and it doesn't differentiate between non-parents and parents. So if we have parents who are divorced and they have joint legal custody, they have the joint right to determine the child's upbringing. If you have one parent who has sole legal custody, they have that sole legal right. The Burkes, of course, are not parents. However, they were conferred by interlocutory order in that petition for custody pending adoption, temporary legal custody of this child. So all of the petition and the temporary order and the custody petition, they were all pending as of August of 2019. And in fact, our trial court, in its final judgment in May of 2023, found that they had remained pending throughout. So by the time of our judgment in this case, the case that is before this court, its final judgment, that temporary custody order had been pending undisturbed in the state of Indiana for 4.5 years. Because in 2019, the department filed a petition alleging that the child was dependent and neglected in the Burke's care. Why they didn't use the ICPC procedures, we don't know. Nonetheless, this petition was filed, and it alleged what is a sympathetic history because this child had several failed adoptions. She suffered from serious mental health issues and some behaviors that were manifested as a result of those mental health issues. But in the department's prayer for relief, the only thing other than the perfunctory things that it was already entitled, the only thing it asked the juvenile court to do was to order the Burkes to allow the child to engage in individual therapy with her current therapist. In fact, one of the factual allegations was that the child's best interest was served by remaining in the custody of the Burkes. But contrary to those allegations and that prayer for relief, the department, as admitted in its answer to our complaint, it tendered a proposed emergency removal order, which on August 8th of 2019, the Greene County Juvenile Court signed. Now, that emergency removal order didn't just remove custody of the child from the Burkes, it granted the department temporary legal custody. We contend that exceeded the juvenile court's authority, but nonetheless, that order was entered. A few days later, there was again, as admitted in the answer, there was a contested preliminary hearing the juvenile court continued to exercise jurisdiction. It set the adjudicatory hearing for October 15th of 2019, which I think would anticipate it exercising emergency jurisdiction for 60-some days. But we never made it to an adjudicatory hearing because on October 11th, 4 days prior to that, the department accepted a surrender of parental rights from the child's legal parents. When it filed a motion for guardianship with the juvenile court, we raised our hands and objected and said, hang on, we have an Indiana case. This at best is emergency jurisdiction. The department conceded that the juvenile court's exercise of emergency jurisdiction did not encompass or anticipate the fact that to enter a guardianship order. So it suggested that the juvenile court seek to get a decline of jurisdiction from the Indiana court, which again is a court of general jurisdiction, so that the juvenile court could modify that Indiana court's interlocutory order. The juvenile court thought that was a good idea, and on November 25th, it entered an order that purported to take jurisdiction over all matters of the child.
Did the order purport that it had,
Huh?
did the order indicate that the Indiana court had been contacted and?
It did, and we actually have a transcript of that communication in which the
And the
Indiana
Indiana court relinquished jurisdiction.
The Indiana court said it didn't want the child placed back in their state, which is somewhat of a term of art when we're talking about foster care. Because under ICPC, it's Indiana's financial responsibility to care for a child that is placed in Tennessee on ICPC. So of course, Indiana is saying, we have a child with significant issues, we don't want her placed in our foster care system. So it's not.
Do you agree the Indiana court relinquished jurisdiction?
I don't agree with
You
that.
think they kept jurisdiction even though they said, we don't want the child in custody in Indiana?
So this is not part of the record, but this is the Agnes Trujillo speculation of the day. The
No.
Indiana statute, and we have argued this, we did argue this in the court below, and I think in our first round of dispositive motions. The Indiana court can retain jurisdiction over the general jurisdiction custody adoption matter, but then decline jurisdiction over a dependency, neglect, or child welfare matter, so that the Greene County Juvenile Court could hear that piece of it. Once that piece is concluded, then you would transfer disposition back up to the Indiana court. That could happen based on both states' statutory schemes. That's how I read it, but we don't know what the Indiana court intended because the Indiana court never entered any order. It never gave the Burkes notice that there was going to be a conference. Now, the juvenile court did, the Greene County Juvenile Court did, but the Burkes would have had a right to appeal from the Indiana trial court to the Indiana Court of Appeals if they disagreed, because it's only the Indiana court that can make a determination that Tennessee is a more convenient forum. Tennessee can't take jurisdiction based on convenient forum. The Indiana court has to give it, and there was no order entered. So where we ended up, though, is the juvenile court declared that it assumed this modification jurisdiction, but it never actually modified the order. Because a few days later, the department sent a letter to the circuit court, which we learned had actually presided over the surrenders, and said, oh, well, jurisdiction is resolved. Please enter our full guardianship order, which the circuit court did. Shortly thereafter, the department then non-suits the dependency and neglect case. So Mr. and Mrs. Burke are standing there with still an order in effect from Indiana, nothing to appeal anywhere, because this maneuver had allowed the department to get a guardianship order without ever having to face a day in court as to what is best for this child. Now, we talked a lot about the UCCJEA below. It overshadowed all of the proceedings, but I would submit to your honors that that is not what we should be analyzing this case, what statutory scheme we should be analyzing this case. The UCCJEA can limit a trial court's jurisdiction to hear a child custody proceeding, but it's not the source of that authority. That authority comes from our state substantive law. So when we looked at what the trial court did in its prior surrender proceeding, it was following the statutory authority granted by 36-1-111, specifically 06, that allows the recipient of a surrender to file a motion for guardianship in certain instances with the surrender court. But 06 tells us, and it was R back in 2019, the General Assembly has renumbered it now, it's currently O. The 06 specifically says that it is subject to the restrictions in 02 and 04. 02 simply tells us that a surrender doesn't affect prior orders. But 04 says that if there is an existing custody order at the time of the surrender that gives custody to a third party, someone other than the recipient of the surrender, then the, quote, purported surrender, and that's the legislature's words, is ineffective to free that child for adoption. That any guardianship order that is entered based upon that surrender is void if it seeks to deprive an existing legal or physical custodian of their rights under that prior order. That's the controlling statute here. Because Mr. and Mrs. Burke, even if the juvenile court's removal of physical custody of this child, which we argue is all it's authorized to do under Title 37 on an emergency basis, the Burkes still had the legal right to determine this child's upbringing, just like a parent whose child has been removed on an emergency basis by a juvenile court. They had the right to determine the child's religion. They had the right to consent to certain medical treatment. The department takes the position that because it tendered an order to the juvenile court that exceeded the juvenile court's authority by giving it legal custody on an emergency basis, excuse me, rather than waiting for a dispositional hearing, which is the only time that a juvenile court can grant temporary legal custody, that they superseded and obviated all of the rights that the Indiana court had granted to the Burkes. And that's simply not our statutory structure. Title 37 doesn't give a juvenile court that authority. So when we take that and we say, okay, we have to modify the juvenile court's order to only take away physical custody, they were an existing legal custodian at the time of the surrender under the surrender statutes, making that surrender ineffective, and the guardianship order based upon it, void. That's all my time.
Thank you. You have time. Excuse me. You have time for rebuttal. We'll hear from the appellees. Appellee.
May it please the court. Good morning, Your Honors. Amber Barker from the Attorney General's Office here on behalf of the Department of Children's Services. My co-counsel, Catherine Adams, is present with me today as well. Your Honors, this case stems from the Circuit Court's 2019 acceptance of a surrender of parental rights and the subsequent order that granted guardianship of the child to DCS. The Burkes were the prior custodians of the child pursuant to the Indiana court order from 2018, but the child had been removed from their custody and given to the DCS's custody by the juvenile court order here in Tennessee in the dependency and neglect proceeding. This lawsuit subsequently followed after DCS took guardianship of the child and the trial court properly dismissed the complaint. The department asked that the trial court order granting summary judgment to DCS be affirmed for two reasons. First, the circuit court had jurisdiction to both accept the surrender of the parents and to grant guardianship to DCS. And second, the Burkes lacked standing to challenge the validity of the surrender itself.
Let me ask you this. I'm a little confused about the whole reason for DCS seeking removal of the child from the Burkes' home to begin with. Because it seems like the DNN petition was filed just based on the fact that they wouldn't agree to individual therapy. It was only family therapy. Am I missing something? Is that the reason why they sought custody of the child?
The procedure in the dependency and neglect is a little bit odd in this case. The department explicitly did not ask for removal in its petition. It asked for a restraining order essentially to comply with the therapist's recommendations and had the allegations laid out in the petition. I don't know why there was a proposed removal order included with it, but the court, from the record, it appears the juvenile court looked at the allegations and determined that removal was appropriate, issued the bench order for removal, and issued the attachment pro corpus to remove the child into DCS custody. So the allegations in the petition itself were not just that the Burkes weren't complying with the therapist's recommendations. It was that this child in particular had been adopted multiple times across state lines at that point, that there's an allegation that the Burkes had admitted to purchasing the child from the parents in Indiana, that she had been a victim of both sexual and physical abuse in the prior adoptive homes. And so then at that point, she was then having the behavioral and mental health issues that she was in therapy for, but the therapist had recommended individual therapy. The Burkes would not allow that, and the child would sit in Mr. Burke's lap during these therapy sessions, and she would look to him for answers to the therapist's questions. And so I do think it's a situation where the conglomerate of all of these facts together
And
raise...
remind me how old the child was at the time.
I'm sorry, I think she was maybe 7 or 8. I apologize, I can't recall her date of birth now. So beginning with the jurisdictional issues here with the circuit court accepting the surrender and then granting guardianship, I'd like to start with the guardianship order itself. It's undisputed that the UCCJEA would apply in this context in determining whether or not the Tennessee court then had the jurisdiction to modify a child custody provision. And so this court said in Stats versus McKinnon that there's a 3-part analysis for this. First, whether in this case Indiana had retained the exclusive and continuing jurisdiction over the child custody determination. Second, whether Tennessee would then have the jurisdiction to make an initial custody determination. And then third, whether Tennessee should have nonetheless declined to exercise jurisdiction. So with the first prong, Indiana had relinquished its jurisdiction. There is the transcript of the conference call between the Indiana judge and the Tennessee judge, in which Indiana agreed that the child should not return to Indiana, that the child should stay in DCS custody in Tennessee, and that Tennessee should have jurisdiction. It was asked whether the Indiana judge agreed for Tennessee to enter an order reflecting that call, and the Indiana judge agreed to that. And so while there isn't an order in this record from the Indiana court itself, the Indiana judge did agree to what was in the Tennessee order. And so that should be sufficient here to show that Indiana properly relinquished jurisdiction here. Alternatively, the court in Tennessee could also determine that Indiana lost jurisdiction because the child no longer lived in Indiana. She had been in Tennessee at that point for about 14 months, 10 months with the Burkes and then 4 months with DCS. And then she no longer had legal parents in Indiana because they had already surrendered their rights. I cite in my case, in my brief, the case of In Re Apex R, which is a reported decision from this court. It's pretty similar. The mother in that case had consented to a termination and an adoption. It wasn't even final yet, and this court found that that nullified her continued residence in another state. As for the second prong for this UCCJEA analysis, Tennessee did have initial custody determination jurisdiction by that point because, again, the child had been here for 14 months. So Tennessee was undoubtedly the child's home state at that point. A home state is established once the child lives with a parent or a person acting as a parent for at least 6 months consecutively. Again, 10 months with the Burkes pursuant to that Indiana custody order, and then 4 months with DCS pursuant to the juvenile court's custody order.
What I'm looking at here is the Indiana court, they never put down a final order granting custody to Tennessee.
That's correct, Your Honor.
Would they have to do that, or would Tennessee be able to pick up from that point once the conversation and they release, and Tennessee would pick up from that point, or what? Or will Indiana have to put down an order?
It's the department's position that it would not, given that there is a valid order here that reflects what the Indiana court was doing in relinquishing jurisdiction and had consented to that. Best practice, certainly I would prefer that there be an order in both courts, but here, because there is an order that shows that there was this relinquishment, and it's based on a transcript. So there's no suggestion in this case that the Indiana court was lying or that it was fabricated in any way. It was simply the technicality of ideally you'd want an order in both states, but there's nothing here preventing DCS from moving forward, nor would it make sense policy-wise. If another state is just refusing for whatever reason to enter an order after it's agreed, maybe it's just pushed it aside and thought, I'm done with that case now, it wouldn't make sense to then prohibit the state that has jurisdiction from actually entering an order. Someone needs to be able to make custody determinations for children, which goes to, again, in the initial custody determination jurisdictional statute 366216, one of the 4 options is even that catch-all provision where no other state is willing to take jurisdiction of this child, then the state can. So even that policy consideration is shown in the statute. And then as for the third prong of this analysis, there was no reason for Tennessee to decline to exercise jurisdiction. The child had been living here. The Burkes lived here. She was in DCS custody here, and the parents, again, had come to Tennessee to surrender their rights to DCS. And so Tennessee...
Tell us again, how did the Burkes, they had custody from under the Indiana court, correct?
Yes.
When did they lose custody, under what?
They lost custody under that initial juvenile court order in Tennessee. And so that is a different jurisdictional analysis. If Your Honor would like me to go ahead and address that, that would be an emergency jurisdiction, which is a type of modification jurisdiction under the UCCJEA, but it is a different provision. That is 366219, in which the child is present in the state, and the child was present here, and the child is either abandoned or it's necessary in an emergency to protect the child because the child is subject to or threatened with mistreatment or abuse. And so, again, that goes back to the allegations that were in the dependency and neglect petition. The courts have held that these just need to be specifically alleged threats. And so it's the department's position that the allegations in that DNN petition were certainly sufficient to meet that standard for the court to exercise its emergency jurisdiction under the UCCJEA. While that's not indefinite, ultimately, again, that jurisdictional issue was resolved once Indiana and Tennessee had that conference call and resolved the jurisdictional issue, which gave Tennessee then lasting jurisdiction under the normal modification jurisdiction provisions of the UCCJEA.
So at the time the order was entered saying Tennessee, the juvenile court had contacted the Indiana court and this is what had happened, what was the status? Who had custody?
So that order was entered in November of 2019. DCS still had custody at that time because DCS got custody at the time of the removal, that order, in August of 2019. There was the preliminary hearing, and then the surrender happened in October, and then November was the conference call with the order saying that Tennessee was going to have jurisdiction instead of Indiana. And then after that, in December of 2019, is when the circuit court entered the guardianship order. That is currently the issue of this appeal. Also, talking about the removal order itself, there was certainly statutory authority for the juvenile court to enter that order and certainly to give legal custody in addition to physical custody to DCS. 37-1-113A gives juvenile court the authority to remove a child into state custody. And then 37-1-114A2 and 117B1 also authorizes a court to remove into DCS custody where the child is a probable cause of dependency and neglect, they're subject to an immediate threat of harm, and there's no less drastic alternative to removal. And those were findings that were made by the juvenile court here in the removal order. There is not a distinction made in Title 37 on legal versus physical custody. Custody is defined in a way that appears to include both. It includes the responsibility to care for the child's physical, mental, moral, or emotional well-being. That is not limited to physical custody alone, and it would be nonsensical for a court to only have authority to remove physical custody and give physical custody alone to DCS without giving DCS any legal authority to make decisions on behalf of that child. It must be read to include physical and legal custody. And so DCS certainly had both physical and legal custody, both at the time that the surrender was executed and then again at the time that the guardianship order was entered subsequently. Therefore, as for the claim under 36-1-111Q, previously located at U, the Burkes, again, are foreclosed from bringing a claim to challenge the surrender itself because the juvenile court did properly give custody to DCS. Both, they have jurisdiction and the statutory authority to do so. I also want to briefly note that it is certainly the UCCJEA that would apply in determining these, which state has jurisdiction to make a child custody determination. Again, this court has addressed that issue as well in Apex R. The ICPC is a placement statute. It's meant to prevent children being moved across state lines unlawfully. It is not intended to be a purely jurisdictional statute. Jurisdiction is the entire purpose of the UCCJEA, and that would certainly be the controlling statutory scheme here. And then I would like to spend my last couple of minutes just briefly touching on the jurisdiction to accept the surrender as well, because that is a little bit different than the rest of this case. Surrenders do not fall under the UCCJEA. They are separate from that. They are not part of the child custody proceedings as defined in that statute. A child custody proceeding is a proceeding in which the legal custody, physical custody, or visitation with respect to the child is at issue. It gives explicit examples of divorce, separation, abuse, neglect, dependency, guardianship, termination of parental rights, and protection from domestic violence. Surrenders are not included in this. A surrender, instead, is the document executed in Tennessee to relinquish parental or guardianship rights to a child for the purpose of making that child available for adoption. Our surrender statute, 361111G, specifically contemplates an out-of-state parent wanting to surrender their rights to a child here in Tennessee. That parent can either comply with Tennessee's surrender statute or the other state's surrender statute. Here, the parents chose to come to Tennessee and comply with the Tennessee surrender statute in doing so. And the fact that the surrender has the effect of terminating parental rights does not make a distinction here. Surrenders, again, are treated differently than involuntary terminations. Surrenders are put on special dockets. They don't need to be filed in conjunction with an adoption proceeding. They can be separate. And 361116H explicitly states that the UCCJEA applies to involuntary terminations of parental rights, and that when an adoption petition is filed with or without a voluntary termination or consent, it is also not a custody proceeding under the UCCJEA. And so therefore, it necessarily follows that the surrender itself would not fall under the UCCJEA. And so the circuit court here then did have proper jurisdiction to also accept that surrender prior to that conference between the Indiana and Tennessee judges. If there are no further questions, I'll rely on my brief for the remaining issues.
I hear none. Thank you. We'll hear from the appellant. Rebuttal.
Quickly, to answer Your Honor's question, yes, an order is required from the state that has exclusive jurisdiction. The case it's in the
I'm sorry.
I did it again. I'm sorry. To answer Your Honor's question, an order is required from the state that has exclusive continuing jurisdiction under the UCCJEA. The middle section decided Stack versus Stack in August of 2016, and they relied on 366217 comment 1, which we have noted in our reply brief. So we have a state that has jurisdiction. They have to enter an order, otherwise the case is still
And if they
pending.
don't, what happens to the child?
They still have jurisdiction, and
What happens to the child? I understand you're saying
Indiana. Yeah, I'm
I
sorry.
understand you're saying Indiana still has jurisdiction, but they've said, from the transcripts, they basically said, we don't want anything else to do with it. So what do we do with the child then? If Indiana has jurisdiction, they've washed their hands of it, but they didn't put an order down. What happens to the child?
The child remains in the custody of the Burkes, and if anyone has any
And no court's going to address anything else from that point on? Because
Indiana-
Indiana's not going to.
Well, if Indiana has a motion filed in its court by an interested party, they certainly would. But remember here, Your Honor, and the reason that I have cited to the ICPC, I agree with counsel, it's not a jurisdictional statute. It's telling the court that if we had an Indiana court that decided to sit on its hands, the department could simply contact Indiana and the child would be returned under the ICPC regs. The department had a wide array of protective measures that didn't require any kind of court action to protect this child if they believed that the child needed protecting, which it didn't according to its own petition. There's no emergency. It's an open-ended order, and it was used to circumvent not only the Indiana legal process, but any kind of contested custody process that would occur in Tennessee. This court has routinely modified open-ended emergency custody orders under the UCCJ. I think most of them are to about 30 days. If that's the case, there's no question that the juvenile court could not interfere with the Indiana order that was in existence. But more importantly, when you're deciding this case, imagine that Indiana isn't involved. The department still loses. If we have a grandparent from Knox County who has been granted temporary legal custody of a child, the parent cannot then go to the department and surrender their parental rights and circumvent that grandparent's custody that the Knox County Juvenile Court gave them.
Parent can't surrender their parental rights?
36-1-111, they cannot. To be effective to free the child for adoption without dealing with this other legal custodial interest. Take Indiana out of the equation.
I understand, but you're saying the statute.
36-1-111.
Prohibits, it says the parents can't surrender their rights if the child is in the legal custody of somebody else.
That's correct. 36-1-111-04B, Your Honor. And my time is up because it's going up this time. I got it. Thank you.
Thank you. Of course, thanks to counsel for both sides. We appreciate your arguments and your briefs on this. Call the next case, please.